Welcome to Business Law 1 class. The topic for today is remedies, specifically damages, nature and types, as well as measures of damages. Session objectives. By the end of this session, you should be able to describe the nature of damages, you state the types of damages, and explain the measure of damages. Remedies. The second point is that anytime you enter into a contract and there is a breach, the innocent party must be compensated. So, in equity and in law, that's common law, they all appreciate the fact that, look, when parties enter into a contract and one of the parties breaches the contract, the innocent party must be compensated. So, the maxim goes like this: equity will not suffer a wrong to be without a remedy. Nor should the law. So it means that both at common law and equity, if someone suffers a wrong or if there's a contract and there's a breach, the innocent party should be given the remedy he or she is entitled to. Now, when there is a threatened breach or imminent breach, there must be a remedy. What is then the purpose of awarding damages as remedy? They are saying that the main purpose is to place or restore the injured party in a position they would have been in had the contract been performed. Or what you are saying that, look, you have breached the contract, then the innocent party should be given a certain amount that will help him or her to be at the place that he would have been if the contract has been fully performed. That if there has not been breach. At common law, the only remedy available was damages. It means that if you apart from monetary compensation, you can't get anything again. Now, equity came in to introduce a number of other remedies. Now, the equitable remedies as follows: quantum merit. In simple terms, what the work that you have done. So, when there's a contract but you have not, the compensation or the consideration has not been determined, the court will determine the work that you have done to give you appropriate remedy or appropriate amount. In some cases too, you'll be performing the side of the contract, but the other party will prevent you from doing. In that case, you should be paid an amount equivalent to the work that you have done. We also have money had and received. In the case of Frafa versus Boakye, FNB, Frafa versus Boakye, the court indicated that where money has been paid or deposited for a benefit, but consideration has been wholly failed, then the person who paid the consideration, the person who paid the amount or deposited the amount but have not received any thing in return, is entitled to the money that he or she has paid. For instance, you enter into a contract with someone to supply you 10 bags of cement. You made the payment, but the person failed to supply you with the 10 bags of cement. You can bring an action for money had and received so that you can recover the amount that you paid to him or her and probably ask for interest. That's what we mean by money had and received. You also have specific performance, whereby the court makes an order for you to perform what you undertook to performed under the contract. Reinstatement occurs where the court makes an order that the person should be put in the position or in the work that he or she was dismissed. And normally, this is applicable in government institutions. Injunction is whereby the court makes an order prohibiting either a party or the parties from doing certain things, or ordering the parties or a party to perform a particular act. Rescission is whereby the person applying for the innocent party applies for the court to set aside the contract so that he or she will be discharged from future obligations. Now, ratification is whereby parties or a party applies to the court for corrections to be done in the document containing the contract. So the ratification is on the document itself, but not the contract, the actual contract. Maybe there are certain things that should have included in your writings, but the conversation that you had and what was on the paper is different. So the parties can apply to the court for the court to ratify, or they can both agree and amend their contract as well. You should understand that the remedies are not mutually exclusive. The remedies are not mutually exclusive, as stated in the case of Equiana Construction Limited, the Bank for Housing and Construction. Bank for Housing and Construction. What this simply means that the fact that you are claiming for one of the remedies does not prevent you from claiming the others. So you can claim more than one. You should also understand that it has been stated in the case of Albert Esamoah and Associates, the Zane Communication Limited, that a remedy may be claimed in alternatively. So you can have an alternative remedy. So if what you are asking for instance, if you are asking for specific performance and damages will be okay, the court will rather grant you damage rather than giving you specific performance. But where damages can be granted, specific performance will not be granted, meaning that if awarding damages will solve the problem, the court will not bother itself to grant specific performance. You also have the various types of damages. You have the compensatory damages. Here, the court award damages against the one who has breached the contract and in favor of the innocent party. For instance, maybe the person has incurred medical expenses, has lost some rent or income. The court will award these damages to compensate the person. General damages. It has been stated in the case of Hadley v. Bassadel that the general damage is the damages that flow from the natural breach of contract. So it's obvious that when there's a breach, these are the possible losses that the person is going to suffer, and therefore damages will be awarded in favor of the innocent party for all the losses that will flow from the general breach of the contract. Special damages. These are damages that they don't flow from natural breach of contract. However, the party must particularize those losses that he or she is claiming for damages before it will be successful. It means that those damages or losses must be verifiable. It means that you should be able to verify those costs. So you are claiming for special damages of 2,500. These 2,500, you should be able to group or point out what and what constitutes the 2,500. So you did that medical expenses day one. Day one. Maybe someone hit you with his car, so you were taken to hospital. Day one, you incurred thousand Ghana cedis, and this can be from tort, or the special damage can be awarded for both in tort and in contra. So since we are dealing with contra, let's use contra. Perhaps you have entered into a contract for someone to supply with certain items. Now the person failed, and you are claiming that because the person failed, you don't have any option than to buy it at a higher price. So you categorize the cost, maybe cost A, 1,000, item B, 500, item C, 500, item D, 500, making the 2,500. So the court want to see what constitutes the special amount, what constitutes the special damage you are claiming for. The amount that you have mentioned as a special damage, what are the components of that amount? So you also have the issue of the liquidated damages. Liquidated damages are damages that the parties have agreed upon that in case there's a breach, the person who is at fault will pay that particular amount. It's a specified figure and it is a predetermined amount. So the amount will be determined before the breach will occur, if any. Now the amount should not be in the form of punishment. If it is in the form of punishment, the court will strike it out. We also have unliquidated damages. For unliquidated, there is no specified amount. The court will look at the consequence of the breach and award damages same. We also have nominal damages. Nominal damages is normally awarded by the court in favor of the one whose right has been breached against the person who breached the contract. This to acknowledge that indeed you had a right, but ordinarily you shouldn't have come to court to enforce that right. So that's why you have nominal, something small, to appreciate your right. This to discourage people from bringing minor issues to the court. The court want to deal with tough issues, so they want to save time and deal with the more critical issues. So your trivial issues, the court will sit on it, but the damages that you'll be getting is very small. Measure of damage. This refers to the quantum or the amount that must be awarded. So we are looking at how much should be awarded to you, or how much should be given to you for the breach that the other person has caused. And before they will do that, the court will consider several factors before awarding you that amount. Was the breach coming from the normal breach of contract? Did you take any steps to mitigate your losses? The court will consider all these things before giving you the amount in question. By way of summary, we have looked at the nature of damages as a common law remedy, and look at the various types of damages, and finally we went to type measures of damages. Thank you and have a nice day.